Welcome to the Tailor Law Podcast, your trusted source for expert legal insights on family and divorce law in Ontario. I'm your host, Deepa Taylor, and today we're diving deep into a topic that can shape the course of your future: separation agreements in Ontario. Whether you're considering a separation, currently navigating one, or simply seeking to understand your legal options, this episode is designed to provide you with the knowledge you need to protect your rights and secure your future. Separation is a significant life change, often accompanied by emotional and financial challenges. Amidst the turmoil, one of the most critical steps you can take is to establish a clear and legally binding separation agreement. But what exactly is a separation agreement, and why is it so important? A separation agreement is a legally binding contract between you and your spouse or common law partner. This document outlines how you will handle key issues such as property division, spousal support, child custody, and child support after your relationship ends. In Ontario, a well-drafted separation agreement can help prevent future disputes and provide a roadmap for how both parties will move forward. One of the most common misconceptions about separation agreements is that they are only necessary for high-conflict situations. In reality, even amicable separations benefit from having a formal agreement in place. Verbal agreements or informal arrangements often lead to misunderstandings down the line. A written separation agreement protects both parties by clearly outlining each person's rights and responsibilities. So, what should be included in a separation agreement? Let's break it down. First, property division. Ontario follows the principle of equalization of net family property, which means that married spouses are entitled to an equal share of the wealth accumulated during the marriage. This includes assets like the family home, vehicles, investments, and pensions. However, common law partners do not have the same property rights, making a separation agreement even more crucial for them to clearly define how assets will be divided. Next, let's talk about child custody and access. If you have children, a separation agreement should outline custody arrangements, parenting time, and how major decisions regarding the children's upbringing will be made. This could include education, healthcare, and extracurricular activities. It's essential to prioritize the best interests of the child when drafting these provisions. Child support is another key component. In Ontario, child support is calculated using the Federal Child Support Guidelines, which consider the paying parent's income and the number of children involved. A separation agreement should clearly state how much support will be paid, when payments will be made, and how any additional expenses, such as childcare or medical costs, will be handled. Spousal support is also an important issue. This refers to financial support paid by one spouse to the other after separation, which can be temporary or long-term depending on factors like the length of the relationship, the roles each spouse played during the marriage, and each person's financial situation. Your separation agreement should specify the amount, duration, and conditions of spousal support payments. Now you might be wondering, can you draft a separation agreement without a lawyer? Technically, yes, but family law in Ontario is complex, and mistakes in your agreement could cost you significantly down the road. A poorly drafted agreement might leave out critical details or fail to meet legal standards, making it unenforceable in court. It's always in your best interest to consult with an experienced family lawyer who can ensure your rights are protected and that the agreement is comprehensive and legally sound. One of the biggest mistakes people make is relying on generic templates found online. While these might seem like a quick fix, they often fail to account for the nuances of your unique situation and the complexities of Ontario family law. Every family is different, and a one-size-fits-all approach rarely works when it comes to legal agreements that impact your future. Financial disclosure is another critical aspect of creating a valid separation agreement. Both parties must fully disclose their income, assets, debts, and liabilities. Without full disclosure, the agreement could be challenged and potentially overturned in court. Transparency is key to ensuring that the agreement is fair and enforceable. It's also essential to understand that both parties should receive independent legal advice before signing a separation agreement. This ensures that each person fully understands their rights and the consequences of the agreement. Without independent legal advice, a court might later decide that the agreement is invalid. especially if one party was pressured into signing or did not understand what they were agreeing to. Now let's address what happens if circumstances change after signing a separation agreement. Life is unpredictable. Job losses, changes in income, or evolving needs of children can all necessitate updates to your agreement. In Ontario, separation agreements can be amended if both parties agree to the changes. If an agreement is no longer fair or circumstances have significantly changed, you may need to seek legal advice on how to proceed. Another common question is whether a separation agreement can be enforced. In Ontario, courts generally uphold separation agreements if they were entered into voluntarily, both parties provided full financial disclosure, and both received independent legal advice. However, if the agreement is grossly unfair or one party was coerced into signing, it can be challenged in court. For example, if one spouse hid significant assets during the negotiation, or if the agreement was signed under emotional distress without proper legal guidance, a judge might set aside the agreement. This is why it's so important to approach the process carefully and methodically. Some couples might wonder whether mediation is a better alternative to negotiating a separation agreement. Mediation can be an effective way to resolve disputes amicably with the help of a neutral third party. It encourages open communication and cooperation, which can be particularly beneficial when children are involved. However, even if you reach an agreement through mediation, it's still crucial to have a lawyer review the final document to ensure it is legally binding and enforceable. In situations involving domestic violence or significant power imbalances, mediation may not be appropriate. In these cases, it's critical to work with a family lawyer who can advocate for your safety and legal rights throughout the process. At Tailor Law, we understand that every family situation is unique. Our team of experienced family lawyers is dedicated to helping you navigate the complexities of separation and divorce. We work with you to draft a comprehensive, legally sound separation agreement that protects your interests and supports your future. If you're considering separation or need help creating a separation agreement, we're here to guide you every step of the way. Visit tailorlaw.com to learn more about our family law services or to schedule a consultation. Taking this step today can provide clarity and peace of mind for your future. Thank you for joining me on this episode of the Tailor Law Podcast. If you found this information helpful, please subscribe and share this episode with anyone who might benefit. For more expert legal insights on family and divorce law in Ontario, stay tuned for future episodes. Until next time, take care and remember, you don't have to navigate this alone. Tailor Law is here to help.